Let's get started.
Welcome to the Financial Purpose Podcast. All opinions expressed by me or guests of the podcast are solely our own opinions and do not reflect the opinion of Life Moves Wealth Management. This podcast is for informational purposes only and should not be relied upon for any investment decisions. Clients of Life Moves Wealth Management may maintain positions in the securities discussed in this podcast. Hello and welcome. This is episode 43 of the Financial Purpose Podcast. Today, I am joined by a returning guest, Paloma Goggins of Nocturnal Legal. And Paloma was all the way back on episode 30, which was titled Get Your Business House in Order. And we talked about all kinds of things that you need to do as a business owner to have all of your documents straight and your processes moving along and written down and official and all that fun stuff. So today, though, we're going to talk about the new FTC rule on the ban for non-compete. So, Paloma, can you, hi, welcome, by the way. Give us a brief introduction of a little bit about you.
Yeah, so I'm the owner of Nocturnal Legal. It's a boutique business law firm that focuses on mergers and acquisitions and then outside general counsel services. And kind of just jumping right in on the FTC ban. So kind of at a very basic level, anything that was a non-compete in place previously from employer to employee is null and void at this point, with a very minor exception for senior executives. And that, I think, can really just be like the blanket statement for just launching the episode.
Yeah, no, that's perfect. And now, so the rule was released in April, and you sent your email out, which is when I pinged you and said, hey, we've got to talk about this. And but there's a date in September, if I remember correctly, of when it actually takes place because of like the 6-month window or something like that. But it's already being challenged.
Yes. So it's the rule is essentially it's pre-publication, right? In a way, is I guess the best plain way to put it is that the rule was passed by the FTC, and then there's a period in which it'll ultimately be published and put into practice. But of course, it's given space to have people come in and try and challenge it. And if you read into so the FTC published an extremely lengthy document about why they've done what they've done and the purpose and some of the definitions and some of the things that we'll get into. But ultimately, the goal is to try and allow for more competitive behavior in the workforce and workplace because, first and foremost, they view a lot of the anti-competitive restrictions as something that could prohibit someone from making a living, but also stifle ingenuity in the workplace, essentially.
Yeah. Yeah, and so I have a leg, I think, on both sides of this issue, right? And I think a lot of business owners might, because at some point I was restricted by a non-compete, and at some point I refused to sign one in the past, and then I eventually launched my own firm. A non-compete would have been a showstopper for that, right? And in my business, a lot of times it's non-compete and non-solicit, which is another set of handcuffs, basically. So it gets really interesting, but to your point, they're estimating that there's going to be some efficiencies, higher wages for workers, more people starting businesses, more ingenuity, lower healthcare costs, those kinds of things. Where do you see a lot of business owners from your perspectives coming down on this ruling?
I think, by and large, most business owners are going to feel like this is problematic, right? Especially in businesses that are service-based, where you have a book of business and it can be exceptionally hard to prevent someone from essentially taking the knowledge they've learned while working for you and create a competitive business that duplicates the effort, right? And you can, the rules don't prohibit a business from having non-solicitation, which can cover employees and current clients. So I think there is protection from that standpoint, but you're not preventing employees from coming in, getting trained, learning the ropes, and then going out and completely creating a competitor in the industry or your community.
Right. And you can also, under this rule, as I understand it, you can still have non-disclosure, which is smart
Yes.
for any business, right? And then you can get into, of course, patent rules and things like that, right? So where do you see this rolls out? What do you see as the positives for how this gets implemented?
I mean, I think one major positive is that there are a lot of employers out there, corporate employers, like setting aside the small businesses that might be impacted by this rule. I think there are, by and large, significant corporate clients out there that have, hundreds of employees, some of which are stuck with pretty stringent non-competes. And I think I've run across a lot of people who have been impacted, like yourself, where you're working for a company, you want to move on to a new endeavor or a new project, and this non-compete is so broad that you really can't do that without sitting out for a period of time or going into an industry that maybe you have no knowledge.
Or moving somewhere else.
Or moving to a new state.
Right.
I mean, as to what degree you want to go to extremes, right, to be able to get around the non-compete.
Yeah.
I think the hard part, too, is that a lot of employees don't have the financial capacity to challenge broad sweeping non-competes that aren't probably legitimate, right, because they encompass or blanket the entire United States, which previously, kind of talk about it, because it's obviously right now it's going to be, currently as it stands, it'll be banned. But previously, most non-competes have to be reasonable, right, in nature. So a lot of people would sign non-competes, which were so broad in nature that arguably they probably weren't very enforceable. But what are you going to do? You're going to pursue a giant corporation in a legal matter? Most people aren't going to take that road.
Right.
So.
And I think that's always been kind of the weird thing with non-competes is that a lot of times they are difficult to uphold in court, just because of I think with the FTC, the spirit of what they've done here, right, to try to remove the restrictions from somebody earning a living in their area of study, expertise, the town they live in their community, that kind of thing. But you're right. I think a lot of people just go, well, I'm bound by this thing. I'm not going to fight their, whatever high-powered attorney, because every single major corporation is lawyered up for those kinds of things, right? And they'll come after you, just to make your day hard for no other reason.
Make a lesson, right?
Yeah.
They don't want other people to pursue breaking a non-compete, so they have to pursue you,
Right.
even if they don't think it's a high risk.
Right.
They don't want everybody else to follow suit.
Right. Yep. So what do you see as something that might kind of look as maybe a negative to this kind of rule coming down?
I think from a negative standpoint, I mean, going back to the ability for people to learn and compete in the same community, I think, the one saving grace is that it's not applicable to merger and acquisitions. So in that space, someone who's selling their book of business, maybe as an asset sale, can't go out and they can still be, tied to a non-compete, whether that's 2, 3, 4, 5 years, whatever they've agreed to in contract, still be fully enforceable. I've actually been recently asked by a broker, what's the difference now if you sell a business and you're then going to be employed still by the business for a period of time? How does the non-compete ban differ, right? And the FTC, the FTC rule is not specific enough with that regard. They just talk about how it's not applicable to mergers and acquisitions. However, I would argue that the difference would be that you would still, as a seller, be obligated to that non-compete in the purchase agreement, whatever form of purchase agreement you've signed. Mm-hmm. But then you wouldn't have a second layer of a non-compete in the employment agreement, right? So if you had people that were in the business that you assumed as workers and they had an original employee document that had a non-compete in there, that would be null, right?
Right. And so that is in that situation, because you are, your primary area of practice is mergers and acquisitions.
Yes.
So in that situation, you would have a non-compete on the selling owner so that they don't collect the money and then go start a competing company. Is that correct?
Correct.
That's why you would do that?
Yeah.
Yeah. And then the same for their employees, right? And so some of that is just, you would maybe as the buyer be prepared to pay retention bonuses or something of that nature, right?
Yes, and I think to kind of even parse it out even further, the one concern I think that remains in the M&A space, especially in a small business M&A space, is to what degree are some of the other employees capable of going out and reproducing, not in the same capacity maybe as the key owner, right? But if there's been a right-hand man or woman who's been along for the ride and they remain employed, or even if they don't remain employed, how does this non-compete ban really play a role? And I can tell you, the non-compete in a purchase agreement is only encompassing for the people that have signed it, right? Mm-hmm. So if you wipe the slate clean of all the employees that used to be part of the business because you're just gutting it with the asset purchase, there's potentially no protection there for the employees that have moved on and might be privy to information that part of operations or kind of taking a sidestep. So there are a lot of issues in the NDA confidentiality space about what is deemed confidential information and what is just knowledge you've consumed and learned as part of being an employee, right? And so I think one of the issues that remains is if someone can remember it without looking at a piece of paper with a list on it, how do you prove that they've utilized confidential information? And so that always becomes a battle. And so I think one of the negatives is that this non-compete ban is great from big company to many employees that might have their livelihood threatened. I think it's not so great from a small business perspective.
Mm-hmm. Yeah. Yeah, that makes sense. And going back to the larger company, there is an exception in here for senior executives, as I recall.
There is.
Senior executives. So talk a little bit about that.
Yeah, so the senior executive exemption is essentially someone who was in a policy-making position and then made $150,000 roughly or more. 151
and some change, yeah.
And so the threshold then becomes, I think in the rule itself, and I don't know if I went into that level of specificity in the news blast, but essentially the threshold for income includes commissions, it includes all these other pieces, so it's not just
a
flat salary.
Gotcha. Okay.
But the and is critical there. So even if you've hit the threshold monetarily, compensation-wise, you still have to be in a position of policy-making power, which the FTC does kind of opine on a little bit on the website about how it's someone who has had sweeping decision-making power in creating policies that govern the organization, with the idea that it's the president or the vice president roles. The C-suite executives is really what they're targeting. Mm-hmm. And even on the website, they say it's their intention on the senior executive exemption is really only to target about 1% of workers. So it's a very narrow attempt to try and say, if you're a C-suite executive and you have a formal employment agreement and you're making policy decisions, you've hit the threshold, you're probably stuck with that non-compete. There's no exemption. No ban on the non-compete as part of the employment document.
Okay. And I had a thought on that, and I have since that train left the station right after you finished talking. I was like, well, I don't know what I'm going to ask her now. So
I'm sure it'll come back to you in just a few minutes.
That's perfect. Okay. So so let's A lot of what I see, because, you know, who I tend to talk to, who I work with in my business, a lot of smaller business owners, right? So just like bootstrapping entrepreneurs, couple of employees, these aren't mega businesses, right? What do those kinds of people need to start thinking about as this gets implemented? Because, well, before we do that, I remembered what I was going to ask you.
Nice.
Okay, so pin that. Related to all of this, what happens, because this is supposed to go, what's the date? September 30th or something like that? Does that sound right?
I think so.
Whatever the date is. Anyway.
Yeah.
Okay. Whenever it's supposed to go, what stops that from happening?
I think it would take a lot. Because once the FTC puts out a rule, I think it would have to be challenged in such a way legally within the system that it becomes the FTC has to retract what they've done. And what the FTC has been doing for the past however long it's been thinking about implementing.
This isn't just like a
right.
sudden thing, right?
Yeah, so it's been years in the making. So I think for them to back off, very unlikely. I think if anything, in the process of it potentially being challenged, there might be clarification rules that come out or additional exceptions or, things that might address key concerns that weren't previously addressed. But to be quite frank, they've had a lot of time to think about it and to come up with the data to back their decision. So
Sure.
I'd be really surprised if it doesn't just in full get implemented on the date of publication, and then maybe the challenges come later on. And I wouldn't be surprised if the challenges come later through litigation efforts, right, between
Right.
parties. So I think we'll just have to wait and see. I think what's nice is that they have put out on the website a short guidance to businesses in an effort to, I think, quell the fear of like, I have to go in and make all of these document changes to comply.
Right.
There is no obligation, which I think is really nice. They've thought long and hard about small business owners who might have a decent amount of employees that they would have to go back and spend legal fees and contract fees and all that. So,
And just the time of meeting with everybody.
Yes.
And then anytime that you change documents, you open doors for distrust, right,
Oh,
between the
yes.
employer and the employee. So yeah, that'd be a mess.
yeah, absolutely. So I think it's nice that they've pretty much published and said, look, you don't need to change anything. Just know the non-compete you have in that contract doesn't mean anything anymore. I do suggest, though, for anybody, small or large business owners, if you're hiring new people, don't continue to use the same contract you used previously and have people sign non-competes, even though you know that they're not legitimate. I think it just adds to the muddling of the clarity of the contract, right? So I have been advising my own clients, like, look, moving forward, even if the contract, let's say they had an independent contractor agreement and it expired, and so they're now at a point where they can renegotiate some of the terms, let's redo the original contract, which originally had the non-compete, so that it's missing.
Sure.
For clarity purposes.
Okay. And I think that's going to where I'm going to pull the pen out and
All right.
bring that back in. Because if this isn't going to get, vacated in any way, and I know that as I recall, the U.S. Chambers of Commerce have challenged this law, or they've brought a lawsuit forward, right? And that's a big deal. And I imagine because of the Chamber of Commerce that they're probably more focused on the smaller employers, because most chambers, that's who's a member. You can get the signatory members or whatever, the high-level members, but they're not really represented there. So if this is not going to be vacated, so this is going to stand, employers have to make adjustments, employees have to make adjustment, however that is, right, which basically just gives the employee a little bit more freedom should they choose to leave. But how do small business owners, other than what you just said, or in addition to what you just said, they don't have to redo old contracts, they need to rewrite new employment agreements. What else do they need to be thinking about or doing or even communicating to their employees?
I mean, I think first and foremost, any small business owner that's been bootstrapping their business, who perhaps doesn't have contracts in place without, or really slap together contracts.
You mean the ones that you can download and just fill in the blank?
All those poorly drafted templates you can find by Googling the name of the contract you need, and it just pops up.
Right.
I think anybody who's at that point and has the capacity to sit down with a professional, I think it's time, right? Because let's say the template just so happened that you pulled off the internet to have the non-compete in there, and it doesn't have all the other meat and potatoes that would protect you, which is the confidentiality, the non-solicitation. Now is the time to get your ducks in a row so that you have more protection in place moving into the future. I think also business owners are going to have to think long and hard about what access they give to their employees, depending on the role that they have and what level of trust they can use, right? And I think that's unfortunate because without and granted, a non-compete is far more, in my opinion at least, something that's pursuable in court than just a traditional NDA or some sort of confidentiality language, which we touched on briefly.
Right.
But I think when it comes down to your sales folks, right? I think that this is a big piece of it. Your sales folks might have access to all your pricing, all your discounts, all your client, your existing customer sheets, especially if they're inside sales, right?
Suppliers, your cost,
so
margins,
many things that
right?
could undermine the business. And if the original contract that you had signed didn't have the right confidentiality in there to at least provide some layer of protection, that's something that's critical at this point. But also moving forward, if that person isn't subject to a non-compete, what can they do? How dangerous can they become if they're crushing it out there? Find an alternative solution that's maybe a direct competitor with you or comes up with a directly competitive service or whatever it may be, right? And just goes out there and pops up its own shop. I think it's really difficult to conceptualize what that might look like for small business owners in the future.
Yeah. I mean, that's definitely it's definitely a major challenge. There was a bulletin that went out from Michael Kitces, which is a big name in the financial planning industry, and they do a lot of research. And when they publish an article, it's not an article; it's practically a magazine, right? It's like very in depth. And so they talked a lot about from the financial advisor, from the RIA space, what it looks like to not have these non-competes in place, and then how you can, change your enforcement standard to specifically non-solicitation, because that's really the risk. If you go out and you start your own firm or you go join another firm somewhere, as an advisor, you want to pull clients with you, and that's a major risk for the other firm. And so that's always been a challenge, but even those are somewhat subject, I think, to come up in the clarification, just because what exactly would be considered a solicitation, right? So is it I call that person and ask them to come work for me? That's a solicitation. I bump into them in the supermarket and they say, hey, where'd you go? What's going on? I tell them what's going on. They come over. Is that a solicitation? Right? Same thing if they call you after they know you left. Is that a solicitation? So I think there's a lot of gray areas still kind of baked into this, and maybe that's what these challenges will hopefully clear up industry by industry, right?
For sure. And I do think that the one thing that the FTC does make clear is that the ban is not inclusive of any of the original non-solicitation protections. And because of that, and I think it's going to remain a pretty hard stance, I think the level of clarity at which your non-solicitation provisions in your contracts are drafted is going to be critical. And I think people don't realize is that pulling a provision from a template you found online or even something from a previous employer, there are so many nuances that can go into a non-solicitation provision that you might find that the non-solicitation provision that you have allows for solicitation of employees that you fired, even for no good reason.
Sure.
You just fired them, and then all of a sudden they're up for grabs, and they are just as dangerous as the employee that voluntarily left. So
Arguably more dangerous.
yes.
Yeah.
So I think there's so many nuances in there that people don't think about that can be drafted around, or at least contemplated when you're drafting.
Yeah. Okay. And so when you're drafting, right, and somebody, you said that it's a good time to contact a professional. And again, Paloma Goggins, Nocturnal Legal, not a paid solicitation. But so when you're walking somebody through that process, right, and you can get very specific for their particular industry, their particular service, right, when they're working with you. What are the types of things that you're able to nuance in that document? Walk me through kind of the process where, let's say if I call you and I'm hiring somebody and I say, Paloma, I need to have this written. You know my business very well. So what are the kinds of things that we would walk through, or we would talk about, or you would ask me about to help get really laser focused on what that document needs to say?
Key questions I would ask are, what are you sharing with them? Give me a detailed list of what you're giving them access to in the business. What kind of information will they have access to on a regular basis? Will they be the ones that are building, especially in an agency setting, are they building their own book of business, or are they, I think monitoring and caring for your existing book of business? Because those two are very different.
Very.
And then I also think, some other key questions are, what level of autonomy are they going to be given? Because that can play a kind of a critical role, right? If you're just going to let them loose out in the real world and they're out there soliciting people, is that going to play a role in sort of their perspective on how their role is within the company or within the business, right? Mm-hmm. I'd also want to ask, what's the long-term vision, right? Is this person being trained to stay? Are they someone that might be replaced by someone else later down the road? Are they just temporary, or are they looking for something to fill their time temporarily? I think the evolution of where someone is in the employment, right? If they're just out of school and they have all sorts of potential, that might be a different risk level than someone who's semi-retired, just looking to fill their days, who's not going to pop up a competitive agency at the end of the day, right?
Sure. And they're not likely to be poached by somebody else or recruited or whatever.
Right.
Got it.
So I think, those are some key questions. I think also kind of just getting down to brass tacks, do you have other employees that could be potentially poached later on? We want to make sure that the document encompasses everyone, both current and past, because inevitably everyone, even if someone's only been there for 6-7 months, they still have key information about your business.
You would hope so. Yeah.
And then, just perhaps talking more about the overarching concerns about what does the relationship potentially look like when and if someone is terminated and they're not looking to voluntarily leave. How dangerous can they become with the information that they have at their fingertips or through the employment process?
Yeah, and since also because a lot of the work I do is around exit planning, and a lot of the work you do as an M&A attorney is around exit planning. So is there anything additional that an owner needs to be thinking about in the lens of exit planning? Even though that's a 3 to 5 year window most of the time, there's still some things that we have to just shift our thinking around, because there is an endpoint coming and it isn't just an everyday activity. So is there anything additional they should consider?
Yeah, I mean, I think overall, right, going back to the non-solicitation piece, right, because this is what everyone is going to hang their hat on at the end of the day with the non-compete gone.
That's the next thing, right? Yeah.
I think with non-solicitation becoming such a critical aspect, I think knowing how someone might try and solicit, to your point, going back to what is solicitation, a lot of times how I will draft a non-solicitation provision is that they can't directly or indirectly through someone else try and essentially either cut off a pre-existing relationship or get them to terminate the pre-existing relationship that they have. And it's centered around current relationships, right? Mm-hmm. But then if you get into the nitty-gritty and you start thinking more like a lawyer, like, well, what's a pre-existing relationship? Is it one that's still a current client? They haven't told you they've left, but you haven't worked with them for a couple of months. And granted, in your situations, it's a bit different, right? But in my situation, I might have a client call me, don't hear from them for a year. I get another call. They have new contracts that they need drafted, or perhaps they're planning to exit, whatever it may be. There are blips in time where a smaller business might not immediately have a need to work with me. And so I think in a lot of instances where a business doesn't have constant interaction or constant retention with that client in an overt way, how can you draft the solicitation, the non-solicitation provision in a way that encompasses, unless someone has overtly told you that they're leaving as a client, they need to remain under the non-solicitation as a current client.
Sure. Yeah, that makes sense. That makes a lot of sense, because I would think that's actually a really good point. The frequency of your interaction with that client, that's going to be probably non-existent in any kind of downloadable template.
Correct. Yeah. No, and I think just funny thing, I was just talking about this the other day with a client of mine, and they were saying it's crazy how much time lawyers spend on working definitions in the contracts. And I had just taken a continuing legal education credit where a woman quoted that legal definitions are the number one most litigated factor in contracts. And so now I like to quote that to my clients because I've always known it's important, right? But it's nice to know that there's a stat behind it. So when you think about the protections that are going to go into future contracts, whether they're W-2 offer and an independent or an independent contractor agreement, regardless of which route you're going, you still need to be conscientious of how you're defining pre-existing clients or pre-existing customers.
Yeah, that makes sense, because terms are terms, right? But you're not going to litigate over terms often. You're going to negotiate those.
Yes.
So, okay. Well, this has been really helpful, Paloma. What else would be important to cover that I haven't asked, or?
I think we've covered quite a bit of it. I mean, obviously, this is an evolving topic. I think it'll be interesting to see if anything comes out of any challenges that come up. Mm-hmm. I think there are a lot with regards to the way that it's being challenged. I think there are, and I even touch on it in the news blast, there are some aspects of it that remain a little unclear. And inevitably, whenever a new law or new rule comes out, there is always these gaps. I think the IRS is like the most notorious for having gaps, right?
No, not the IRS.
I think there's a couple of areas where, you look at the rule, you read through it, and you say to yourself, but what about this? Mm-hmm. And I think it's going to be left up to a lot of people and their lawyers to use discretion on what is technically legally enforceable, right? Might get into some contracts and might ultimately be litigated. And that will be the guiding factor, I think, moving forward. So, one of the things I had mentioned in the news blast, and granted it's not explicit, but if you have members in an operating agreement, a lot of times you have provisions in there that stipulate you can't compete.
Yeah, that's it. That's right.
And I was just thinking about this because, of course, as a member, you don't want people who have intrinsic knowledge about the company to go out and be able to pop up a competitor while they're still a member and benefiting from being in this other business. So I think the nuance there might be that as a member, you're still going to have this anti-competitive restriction. But then if you're employed by the company while also a member, where does the delineation go? So I think there's all sorts of nuances that will create additional litigation, unfortunately, in the future.
Yeah, that makes sense. And on the litigation side, is there still a window for litigation to occur between now and whenever the date that this is official in September? Are there still cases that will be heard, or will those just kind of be, somewhat settled outside of court? Or, I mean, how do you see that happening?
That's a good question. Not being a litigator myself, my assumption would be that if there was a pending case that hasn't been decided, that it would just be dismissed at that point.
Mm-hmm.
But I mean, for all the people who have gone through litigation and come out the other side with a win or a loss, it's all going to be retrospective. It's not like you can. I'd actually, that's a really great question. Could you potentially, as a litigant, have some sort of damages in the future? I have no idea.
I wonder. Yeah.
But sometimes the possibilities in the world of like legal disputes is just unlimited.
Well, if there is, I am of the mind, and this is true for, we can find examples of this in almost any, especially service-based type business. But if there is the possibility of a damages award to be had, there's an attorney that will try. So I'm sure
That's true.
somewhere. Yeah,
That's true.
Yeah. Okay. Well, Paloma, people are going to have questions about this, I am sure. How do the listeners find you? By the way, one of the things I appreciate about you is that you're very good at keeping us up to date on these kinds of legal changes. You've done this a few times with the big stuff. And you give really good networking tips on your social media. So
Thanks.
those two things, which, by the way, anybody can follow Paloma. So if you want to give your contact, maybe even your socials for those networking tips. And
Yeah, no. So you can reach me by phone. It's 480-582-0094. Or you can go on my website, which is nocturnallegal.com. And you can schedule a meeting right through my website. And my social is also at Nocturnal Legal.
Perfect. Well, Paloma, thank you so much for joining me again.
Thank you for having me again.
Yeah, gladly. And this has been a lot of fun. So thanks again. And until next time, go be financially awesome. Thanks for listening to this episode. Be sure to like, subscribe, and share. To learn more about your financial purpose, visit lifemoveswealth.com.